Hello, and welcome to our next session. This is topic number 6, evaluating Board of Director actions and standards of review for doing that. Now, this is actually a very important topic. The powers of the board enable them to do a whole variety of things. Many of these things, the decisions that they make, implicate parts of the residents' lives that are very, very important to them. They produce strong emotions. They make decisions about things like pets and parking and display of flags and religious symbols and political signs and just all sorts of things. They make decisions that affect people's finances, their home finances. They decide whether to impose special assessments, what the regular assessment should be, how much to set aside for reserves, what repairs to make, things of this sort. These are very important decisions. They have consequences for people. And the problem is that the Board of Directors members and officers are unpaid, untrained, and basically unsupported amateurs. They are volunteers with no necessarily any qualifications, really. And there are rare exceptions to this, of course, particularly in big condominium developments or big HOAs where you have lots and lots of people, and if they're kind of an upscale population, then you might find a lawyer, a corporate director, or something like that to serve on this. Someone who really knows how to run meetings and do budgets and all this. Most of the time, you don't have that. In small developments, you almost never have that. And like a 6-unit or 10-unit condo, there might be, especially if it's a lower price condo, there might not be a single person in the association who has any professional training or background or higher education. It's entirely possible. And so they don't know how to do many of the things that they have to do. Their only support, in most cases, is professional property managers and attorneys, and other vendors, contractors, mostly property managers and lawyers. But how good are they? Well, there's no defined specialty for attorneys, common interest community association lawyers. There is a professional organization they can join, the Community Associations Institute. They can take courses if they want to, but the bar associations don't certify these as professionals. And being a real estate professional or specialist doesn't mean you know anything about common interest communities. What about property managers? Well, there are only 8 states in the country that even require them to be licensed or professionally certified. Alaska, the District of Columbia, which is of course not a state, but still, there are a lot of condos there. Florida, Georgia, Hawaii, Illinois, Nevada, and Virginia. The rest of them, you don't even need a license to be a property manager. So many of these people are quite good, others are horrible. And how do you know if you're a board of director member? How do you know whether you have a good one or a horrible one? So often, these volunteer directors and officers don't know what to do. They sometimes do the wrong thing, or they do the right thing, but they do it the wrong way. Such as, I've seen this a number of times, amending their documents and then not recording the amendments because they just don't know that they're supposed to do it. And just causing all sorts of problems for themselves because they did something that made a lot of sense to do, but they just didn't know how to do it. Now, in most cases, the only way to challenge the actions of a board of directors or the corporation, the officers, directors, is through civil litigation. There are 5 states that have an ombudsperson office: Colorado, Florida, Nevada, Virginia, and Illinois. As I said, this office is gearing up to start doing ADR, but like the other states do. But I don't think that's really functioning yet, and we'll have to see how that takes place. But you've got the rest of the country, and in these 5 states as well. If you want to challenge the actions of a board of directors, you have to get a lawyer and go into civil litigation in most cases. I mean, they're really, other than just working within your association, there's no easy way to do this. But when that happens, and it does happen, and it happens because of these decisions being so central sometimes to people's lives, when it does happen, we need to learn what the standards are for reviewing the board actions, and that's what we're going to do here. The obligations of the board of directors are both legal and practical. Um, in certain situations, they have to act. They have to do something. There are times when they must act. And when they do that, they have to act in compliance with the laws, in compliance with the governing documents. And they have to use good judgment, business judgment. And we're going to be talking about that and how that works. And then when they act, they have to consider their options, so that they have to think about how business-like they want to be. How much do they want to act like a business versus how much do they want to act like a community governing body, and take people's feelings and interests into account. Sometimes they need to refrain from acting even when they can. They need to use discretion, prudential considerations of bad press, and the nature of public opinion in their development. These things need to be thought about, aside from just things like property values and so forth. There's always a concern about waiver and estoppel. In other words, they're concerned that if they don't enforce a provision of the governing documents, that they will lose the power to enforce it in the future. That the next time they try to enforce it, someone will say, well, they don't really enforce this. They've waived the right to enforce it. They should be stopped from enforcing it. And as we talked about, these are not realistic concerns as long as the board can state the reasons for their decisions not to act and their reasons to act in other cases. In other words, you should maintain records, make sure there's a written record of why you made these enforcement decisions, so it doesn't appear arbitrary, or it doesn't appear that you have completely waived a provision. So sometimes they act, sometimes they don't act, and these are decisions. They can be challenged either way, whether they act or they don't act. An analogy here would be the police power of the state and local governments in this country. Under the 10th Amendment, they have what's called the police power, the power to protect the health, safety, welfare, and morals of the population. Well, you know what? Many associations have language in their documents, and there is case law using similar terminology when courts are trying to decide what an association should or shouldn't do. You might ask yourself a question. Are city councils better able to make these discretionary decisions than association directors? And one reason they might be is because they have a lot more institutional support. And they have professional city managers who can get master's degrees in public administration and all sorts of things. Organizations like the National League of Cities, there's all sorts of data, other levels of government support cities. You know what? Association directors are largely on their own. And I have been saying for many years that I think the task of running these associations is often places too much of a burden on all the owners, especially on those who serve as directors. And in my opinion, they need a whole lot more institutional support than they're getting. But that's for you. You can make up your own mind about that, but that is the way it seems to me. Now, let's talk about the kinds of functions that they have to make decisions about. And these decisions, again, often become the subject of challenge, and we'll look then at the standards. One is just managing the common area, the common elements, the commonly owned property. In a condo, that's the whole building, except for the individual unit interiors. In an HOA, you never know what it might be: streets, roads, lakes, anything. This involves decisions about repairing and maintaining property and sometimes improving it. These are discretionary decisions. In some cases, in others, it's obvious that they have to be done, like a leaky roof. Obviously, they have to act. And also, sometimes they have to get access to the individual units for various reasons, to execute repairs, sometimes to inspect for various reasons. And if there's a lawsuit, then you can expect there will be requests to examine the interior of units. If they're, I'm speaking now typically of construction defect litigation, including often destructive testing. They may want to acquire property. It may be significant opportunities or reasons. Sometimes associations have a right of first refusal to buy units. They rarely exercise that right, but it may exist, and it may be appropriate in certain conditions. A lot of the things that lead to problems are rulemaking and the enforcement of rules against members. Also, they often make decisions about competing interests within the development, disagreements among residents over the common elements, such as parking spaces. And then there can also be fee issues, charges imposed on people for various things. It could be the laundry. It could be issues about dogs or pets, and charges against them, or behavioral regulations. And then sometimes it could be about political and legal advocacy. We've mentioned earlier, sometimes they get involved in issues concerning the development of adjacent property or nearby property. In other cases, and this is very common, the board has to make a decision about whether to sue the developer for defects in original construction defect litigation. Big decisions. And no matter what they do, there's almost always, in these big lawsuit type decisions, there's almost always somebody who thinks they did it wrong. Now, historically, the property management industry and all the people who work for associations had a top-down command and control philosophy. They felt the board of directors should order everybody around, never enforce every rule all the time, don't tolerate any dissent, run it like a authoritarian organization. That was a universal approach almost. And this has begun to give, and the reason they did it was because they were always afraid that people would not respect the decisions made by their neighbors, essentially. And to establish the legitimacy of this type of local government, which is essentially what it is, to establish the legitimacy, they decided to tell people to become very authoritarian and disciplinary. This approach has caused all kinds of problems. Litigation, bad publicity, being made fun of on TV sitcoms, getting on the evening news, and so forth. So it has given way now to a more community-first type approach. There was a book by that name. The idea is avoid conflict, emphasize the need for cooperation, emphasize the need for mutual understanding between the homeowners and the so-called community leaders, meaning the directors and officers and their hired professionals. This document, Rights and Responsibilities for Better Communities, comes from the Community Associations Institute, the trade association that works for the professionals in this field. And you can see, if you get a chance to read it, it's in your folder, you can see that it reflects a more flexible approach and an approach that emphasizes mutual education and mutual cooperation. And hopefully that approach is becoming more prevalent across the country. Now, we're going to talk now about the standards, and this is the core of this presentation. Community associations as mini-governments, because that's essentially what they are. Now, there are several different standards of review for the board or officer, director, or corporate decisions. The most basic, and we're going to go through all of them and talk about how they relate to each other. And the most basic is the standard of fiduciary duty. This relates in turn to the most commonly used rule applied in courts to these decisions, which is the business judgment rule, which is a rule of judicial deference to corporate decision making. That relates to fiduciary duty. Other decisions are evaluated sometimes by the rule of reasonableness. It could be the reasonableness of a rule or the application of a rule. And it often applies to sort of behavioral regulation type decisions as opposed to business decisions about money and property. And then we'll talk lastly about quasi-governmental scrutiny. You may recall from constitutional law, government decisions being evaluated by the rational basis test. Is the government action rationally related to a legitimate government interest? And then in certain cases, such as fundamental liberties being infringed on, suspect classifications, we switch to strict scrutiny. The government action has to be necessary, not just rationally related, but necessary to a compelling state interest, not just any legitimate state interest, but a compelling state interest. And then intermediate scrutiny is just kind of in between. And so what I'm getting at is, that's the way we do it with governments. And keep in mind that there are times when associations find themselves being looked at almost as if they were governments and being encouraged to act more like governments. And so as arguments are made in courts around the country, especially under state constitutions that have broad protections for, say, free speech on private property, things of this sort, these quasi-governmental standards that we see applied to local governments sometimes end up getting applied to associations. So we'll take a look at that. Let's begin by talking about fiduciary duty. It is defined in the Condo Act, Section 18.4. It says, that is, it is set forth, in the performance of their duties, the officers and members of the board, whether appointed by the developer or elected by the unit owners, shall exercise the care required of a fiduciary of the unit owners. So that means the developer and the developer's appointed members are fiduciaries. It also means the elected board, after turnover, they are fiduciaries. What does that mean? Well, it means this. A fiduciary is a person who is in a position of trust and confidence with respect to another person. They are like trustees. And that is because the fiduciary has rights and powers that are supposed to be exercised for the benefit of the other person. So, board directors and officers have powers that are supposed to be exercised for whose benefit? The benefit of the owners and the benefit of the corporation. And that is why they are held to the highest possible duty of care toward the corporation and toward the owners. And as it says, they must exercise scrupulous good faith and candor. What happens, though, if their own interests, the fiduciary's own interests, are involved? As they certainly are, because everybody's a member of the association. Well, the fiduciary has to hold the other person's interests at least equal to their own, if not higher. And if they don't do that, if they put their own interests first, they violate their fiduciary duty. So the basic triad, as they call it, of fiduciary duty is good faith, loyalty, and due care. And we'll be talking about that in a little more detail. Understand that breach of fiduciary duty, in other words, alleging that they breached one of these elements of good faith, loyalty, or due care, it is a very common cause of action in lawsuits by association members against their officers and directors. When they sue the association, owners almost always sue the officers and directors, and they almost always allege breach of fiduciary duty. Now, here are some standard jury instructions so you understand what this means when the rubber meets the road here. Breach of fiduciary duty. Corporate officers and directors are not allowed to use their position of trust and confidence to further their private interests. They have a duty to protect the interests of the corporation, and in this case, understand, it would mean the shareholders, and also, in this case, because we don't have corporate profit-making shareholders, we're talking about the owners as well. A duty to refrain from doing anything that would injure the corporation or deprive it of profit or advantage. And then it says that they have to, the jury instruction says they have to have an undivided and unselfish loyalty. No conflict between their duty to the corporation and the members and their own self-interest. Wherever they place their own interest above that of the LLC, or in this case the corporation, there is a violation of the duty of loyalty. Now, the rules that we're applying here were written for business corporations or governments, as you can tell. Associations don't fit completely within the incentive structure of a business corporation or even the average not-for-profit. They're a special entity, but these are the rules that we use. These are the instructions that are given, and so they can be applied. But often there is some confusion when we do these things between two of the basic rules, the business judgment rule and the rule of reasonableness. These are not exactly the same. And as you'll see, the fiduciary duty issue connects very neatly with the business judgment rule and explains how you sometimes end up in the rule of reasonableness instead. And so this confusion I hope to clear up, and also to help you understand what the role of the court is. When is the court going to substitute its judgment for that of a board? When is it going to defer to the board? So let's talk about how this works. First, understand that the business judgment rule, and is sometimes called a doctrine, is sometimes called a principle. So the terms are used interchangeably. But it is actually used for two different purposes, and that's why sometimes different terms are used, because they mean two different things. First, this is a rule of judicial restraint. The business judgment rule limits the extent to which a court is going to scrutinize the substance of the decision that is being challenged. But understand, this rule is used to defend both the decision itself and the directors who made the decision. So one way it has been done is to explain that technically the business judgment principle is a defense of the decision, and the business judgment rule is a defense of the directors. But understand, these are two different uses of this rule of judicial deference. The basic idea is if the procedure is okay, if the procedure by which the decision was made is okay, the court then does not second guess the substance of the decision. So let's look at how that works. First, in order for the business judgment rule to apply and to be used basically as a rule of judicial deference, it has to be a business decision that was within the power of the board to make. If it's ultra virus, it's not going to be protected by the business judgment rule. It has to be a disinterested decision. In other words, it has to be made by disinterested board members who aren't serving their own interests. And this is very important. They have to exercise due care in order to take advantage of this. They have to inform themselves to the extent that they believe as reasonable people that it would be necessary to do so. They have to get advice if needed. This is very important. Now, the question then becomes, how do we evaluate this? They are evaluated as lay people. In other words, when would a reasonably intelligent and informed layperson think to themselves as directors, gee, we'd better talk to a lawyer before we make this decision. Gee, we'd better talk to a contractor. Gee, we'd better talk to an appraiser. And there's no clear bright line on this, but obviously directors are very, the course of wisdom here is to err on the side of contacting your lawyer and asking for an opinion if you think you might need one. And then, and maybe that question might be, hey, attorney, should we get opinions from 2 or 3 contractors before we decide? How should we decide whether to tent the whole building for termites or do spot treatment? Should we talk to an expert? Should we get more? See, so these are kind of common sense lay type decisions, but it relates to as in almost all questions of due care, it ends up being a question of fact. But if they do take the time to inform themselves, they are almost certainly protected. I mean, if you think about it, if they're hauled before a judge and the judge says, why did you do this? And they say, well, we talked to our attorney and the attorney told us to do it and gave us a letter saying this is how we should proceed and we followed their advice. Can you imagine anyone concluding that they weren't exercising due care? Because it's pretty hard to imagine, isn't it? Then they have to act in good faith. They have to do what they really believe is in the best interest of the corporation or the residents. Not being arbitrary, not being discriminatory. They have to not abuse their discretion. This is you see this in some of the cases. I personally think this is really not part of the test, but it's sort of the argument that even if decisions are made exactly as we just described, it could still be such a crazy decision that the judge might say it's not protected. I don't understand how that could be the case. If they follow the procedure, then I don't think abuse of discretion becomes a part of this. Because how could it be made in good faith with due care and disinterested and then be an abuse of discretion? It makes no sense to me. But I have seen cases that use this term. So what do you mean? No fraud, no self-dealing, no unconscionability, no illegality, no ultra-virus decision, no waste. See, all these things are things that you might see alleged, but if the association can show that they made the decision in good faith with due care in a disinterested manner and relied on expert advice as needed, it's very hard to see the decision being challenged successfully. So here are some standard business judgment rule jury instructions. A director is presumed to have acted. This is a presumption. They are presumed to have acted on an informed basis in good faith and in the honest belief that the action taken was in the best interest of the company. This is called the business judgment rule. This only applies if the director is not an interested director and is independent. To overcome the business judgment rule, a plaintiff must show one of the following exceptions. One, the director had a personal interest. Well, look, those parentheses. What's in the parentheses there, I put that in, just to show you what's been violated here. If the director has a personal interest in the decision, that's potentially a breach of loyalty. Two, that the director was not fully informed. Well, what is that breach? That breaches the duty of due care. Or, and it could be any one of the three, that the director did not act in good faith. Well, that breaches good faith. Remember I said this, there's this sort of triad of fiduciary duty: loyalty, due care, and good faith. Note how the fiduciary duty principles actually are the content of the business judgment rule presumption. As long as you act like a fiduciary, you're protected by the business judgment rule. If you violate fiduciary duty, you lose the protection of the business judgment rule. And then you see the judge, the trier of fact, is going to be looking at the nature of the decision and potentially re-evaluating the substance of it. You will not have judicial deference anymore. And the directors will not necessarily be protected. Then you proceed onward to evaluate their behavior in detail. And this is where you get into these questions of reasonableness. Some decisions are evaluated based on the standard all the time. Others only if you don't have the protection of the business judgment rule. But basically, it can be done in a number of different ways. One is this: you can look at the substance of a rule. Is the rule a reasonable rule in this subdivision, in this condo association? You could also find yourself being asked to defend the procedure that was followed and the application of the rule to a particular set of facts. Was that application reasonable? And there's been a big dispute in the Narstedt case, which we'll talk about, in California over how to do this. Is the reasonableness applied to the application of the rule or to the rule itself? As you'll see in California, the Supreme Court of California said, the question is, how reasonable is the rule in this development? Not how reasonable is this rule as applied to this particular owner. So what we're talking about here in reasonableness is that the rules and the decision should be reasonably related to the purposes for which the association was created. That's what we mean by reasonableness in most cases. What is that? Preservation of property values, the health, happiness, and peace of mind of the unit owners that is connected with the enjoyment of their property. That's what we're talking about. Reasonableness in that context. And understand that the Basso case, we talked about Hidden Harbor versus Basso when we talked about amendments. Well, when the, remember the original covenants and the original bylaws are invested with a heavy presumption of validity. But board-created rules have to be what? Reasonable. And so that's why, again, this question of reasonableness comes in, especially when the board makes the rules. And you often see the application of this reasonableness when the board is doing sort of quasi-governmental things, regulating behavior, as opposed to deciding, making a purely financial decision. And sometimes courts really distinguish on that basis. So what is reasonableness in practice? Is it just second-guessing the substance of the board's decision? No, not really. There's more to it. As we talked about, they're looking at the issues of discrimination, arbitrariness, caprice, good faith. And in many ways, I know this sounds confusing, but it's actually kind of sensible. There's a point where the basic issues of the business judgment rule become very similar to what reasonableness is. But if at all possible, in defending board action, you want to defend it on the grounds of the business judgment rule. And if you are attacking a board action, you want to be able to convince the trier of fact that it violated the business judgment rule. Now, the larger issue of reasonableness is, something that I think any board should be able to defend any decision, on the grounds that it was reasonable. I mean, you always, as the association, you want to take advantage of the business judgment rule, but you need to be prepared to defend the substance of your decision if you have to. And so that's always something to keep in mind. And that's why they need to document why they made their decisions. They have to be prepared to defend them later on, maybe 2 or 3 years down the road. So again, here, just refreshing your memory, Hidden Harbor Estates versus Basso. Remember, we talked about that in document amendments. The covenants contained in the original declaration are presumed valid and will be upheld unless they are wholly arbitrary, etc., violate public policy, or abrogate a fundamental right. Rules adopted later often end up being evaluated by the rule of reasonableness, the substance of the rule. The Narstedt case, California case, 1994, California Supreme Court, often cited all across the country, so we need to be aware of this. Reasonableness of the covenant in the abstract versus as applied. The majority of the court said covenants are enforceable unless reasonable. That's California law. Reasonableness is presumed, unreasonableness must be proved. And unreasonable means against public policy, arbitrary, etc. Now, there are various ways of going at reasonableness, but understand they said in the Narstedt case, and this is an interesting case that involved a woman who had cats in her condominium in violation of a no pet rule. And you might say, well, how does this end up being a dispute? Well, because she claimed that her cats were always confined within her unit. They were never, ever outside the unit. Therefore, they were never outside her, her individual interest, her airspace. They were never in the common elements. Nobody could hear them. Nobody could see them. Nobody could smell them. And therefore, it was unreasonable to apply the no pets rule to her because nothing her cats did implicated any of the purposes for which the association was created. Lifestyle, property values, nothing. Nothing about her cats had any bearing on any interest the association was entitled to protect. Now, the Justice Armand Arabian, accepted that argument and ruled in her, voted in her favor and wrote a dissent in which he set out this position, defended that position, and later a law review article in which he defended it. But the majority said no. All the covenant, when we say is a covenant reasonable, we evaluate it in the context not of the application to this particular person, but we evaluate the content in a sense as a covenant in the abstract. Is it reasonable to have a no pets provision in an urban condo like Lakeside Village? Answer, yes. They are justified by various reasons. Safety, sanitation, noise, etc. So the provision is enforceable against everybody because it's reasonable in the abstract, and it doesn't matter these cats versus other. It doesn't make any difference what's going on with these cats. They're cats, so that's all we need to know. So that's, and I think this is the majority rule around the country now because judges really don't want to get involved in remaking every single decision, every single application of every rule that gets challenged in every particular case. It's really more than the judicial role probably is cut out for. I think that's the majority opinion in any event. However, we do get to questions of arbitrariness, and obviously associations have to follow the proper procedure, or they can't, they may violate their own rules in the way they enforce it. So to that extent, the individual circumstances matter. But to say that you can have a rule not enforced against you at all simply because of the way you conduct yourself in your unit, that doesn't seem to fly. And now we also get into issues of the burden of proof. We've covered some of this, but in the particularities of these rules. But understand that I think the way this works is the burden shifts back and forth. Rules are normally presumed reasonable, as we said earlier, but ultimately, the way this normally works is the board has to go first. The board, in either case, in my view, the real burden of proof almost always lies on the person challenging the decision. But I mean, they're the ones who are trying to overturn a decision. But again, with the business judgment rule, understand the the board is trying to take advantage of a presumption here. There are certain showings that they have to make before the presumption kicks in. Preliminary showing meaning that the tenets of the business judgment rule, it was a business decision, we were formed, etc. And at that point, they've done what they need to do, and the burden shifts to the other side. In the case of reasonableness, it's really, although reasonableness of these covenants is presumed in many states, again, you're back in the same position where the board provides a rationale for the decision. What is the rationale for the rule, for example? What is the rationale for the decision? Did we follow our own procedures? And again, the burden shifts to the person challenging it. So I always think of these burdens as shifting back and forth, depending upon who has proved what. Lastly, we're going to talk about this question of quasi-governmental standards of review. This is a frontier area. There have been many attempts to apply these quasi-governmental standards to associations, and so you need to know about this, even though in most cases they will not be evaluated this way, but it can still happen. And understand that it's not just a judicial issue. There are statutes on the books right now in California and Nevada, and a few other states, but these two really stand out, that are where they have these process regulations, regulations of the procedures in associations that are very detailed and very much like what governments have to do. So what I'm getting at is that a number of state legislatures increasingly expect associations to act like mini governments, to act like local governments. The California election statute, that regulates CID elections, is like something you'd see for a municipality. Equal candidate access to association publications and common area meeting space, listing of candidate qualifications, voter qualifications, independent election inspectors. This is true. 30,000 some odd associations in California. Every year they have to have election inspectors on their inspection. Secret ballots, sunshine laws requiring associations to open up their procedures to examination by the members, posting of meeting notices and things. It's just like what you'd see for local governments. Same things taking place for architectural review, assessment collection. They begin to look like little mini governments. And then, of course, the creation of ombudsman offices, which are government employees. So you see, there's a trend toward expectations that associations will kind of act like governments. This is emanating from legislatures. Now, in the courts, there are three theories by which private actors can be held accountable to the standards that normally apply to governments. Understand, as you know, for constitutional claims to be made, there has to be state action. And so if the claim is made against a private organization like a common interest development, how on earth can there be state action? The answer is, well, it's been done. There are three theories that can be used to establish state action by a private entity. The judicial enforcement theory, the symbiotic relationship theory, also called the sufficiently close nexus or joint participation theory, and the public function test, or the functional equivalent of a municipality theory. Judicial enforcement theory comes from the famous case of Shelley versus Kramer, 1948, when an association is trying to enforce a covenant, in this case, a race-restrictive covenant that prohibits people of certain races or other groups, religious groups, from buying or renting in a subdivision. How do you enforce those? Private parties, homeowner associations or homeowners, go off to court and ask the court to enforce it, to nullify a sale or a lease. The Supreme Court in Shelley versus Kramer said, don't come to us, don't come to the courts and expect the courts to enforce covenants that violate the Equal Protection Clause, that are racially discriminatory, because you are implicating the government in the enforcement of racial discrimination, and we're not going to do it. So judicial enforcement of a covenant that violates the Constitution can constitute sufficient state action. Now, does this apply to other areas, to other constitutional liberties, or just the Equal Protection Clause and racial discrimination. The Supreme Court has backed off from that, and they haven't been willing to go there. We will have to see how this plays out in the future. For example, if an association passed a rule that basically banned freedom of speech, and then sought to enforce it in the courts, could the enforcement be blocked by an owner in court using Shelley versus Kramer and the judicial enforcement theory? Well, let's find out. We don't know. Next, the symbiotic relationship theory. What if you have a private organization and a public entity closely entwined in doing the same thing? There's a case, I think it's called Wilmington Parking Garage case, that involved racial discrimination by a private entity that was entwined with a local government. Reitman versus Mulkey is a famous Supreme Court case on this issue. What happened in that case was, in California, there was a law called the Rumford Act, the Rumford Fair Housing Act. It was a fair housing statute passed in 1963 for the state of California. It banned racial discrimination in the sale or rental of housing. The voters, there was an initiative campaign. In California, they have the initiative. There was an initiative campaign that put a thing on the ballot called Proposition 14 that sought to overturn the fair housing law of the state of California by popular vote. It passed 2-1. And it was then challenged before the California Supreme Court, later the U.S. Supreme Court. That is, the initiative was. And the argument was that this initiative created a state constitutional right to discriminate on the basis of race. And it wasn't the state being neutral on the issue. It was the state creating, through initiative, the right to privately discriminate, created it as an affirmative right of citizens of the state of California. And the California and U.S. Supreme Court said, you can't do that. That the state then has become complicit in private racial discrimination, and they invalidated Proposition 14 and restored California's fair housing law on the grounds that the state cannot encourage or coerce private racially discriminatory action. And, so what we have here is, and I bring this up because there are many situations around the country where homeowner and condo associations are intimately involved with the activities of a local government, where they are being used, in a sense, as extensions of local government to accomplish certain tasks. That's why I've been saying forever that this is really, this type of housing is a form of privatization. So claims of racial discrimination, violation of constitutional rights, etc., might get made against an association on the grounds of the symbiotic relationship theory. It could happen. Often they are simply made against associations on the basis that they are violations of fair housing law. In other words, that the association themselves, the association is involved as is subject to civil rights statutes itself, not just constitutional claims like a city, but fair housing law. And that is the way these things usually manifest. But understand there is this theory out there that could be applied. And lastly, and this one has popped up again and again with HOAs, the public function test. In Marsh versus Alabama, a woman, Mrs. Marsh, was a Jehovah's Witness wanting to go door to door and pass out literature and contact people on the basis of her religion, exercising what she saw as her First Amendment rights. Chickasaw, Alabama, threw her out. Why? They said, we're a private corporation. The entire town was a company town owned by the Gulf Shipbuilding Corporation, and their constable, their security guard, was actually a public police officer, a sheriff of some sort, who was moonlighting as a private security guard. But the Supreme Court said, look, this has all the attributes of a municipality. It walks like a duck, it flies like a duck, it quacks like a duck. And if you have a private corporation performing all the functions of a municipality, we are going to hold them to constitutional standards. And that's what they did in 1946. And there's been a whole series of cases, Logan Valley, Lloyd versus Tanner, Hudgens versus NLRB, and Pruneyard versus Robbins, that involved the exercise of First Amendment rights, mostly picketing, on or signature gathering in shopping malls, or in the case of Twin Rivers, the case in which I was the expert for the American Civil Liberties Union. This was a New Jersey case. In that case, it was an HOA. What free speech rights do people have on private property? And this involves not just the federal, but the state constitutions. The Supreme Court in Pruneyard versus Robbins basically said, I'm going to summarize this, there's no First Amendment right to exercise free speech on private property under the U.S. Constitution. However, the Fifth Amendment Takings Clause also does not apply, and therefore if state constitutions or state laws want to expand freedom of speech on private property, they can do so without violating the Takings Clause. Now the question is, how far does that go? That's the basic principle of Pruneyard versus Robbins. And then the Twin Rivers case involved an attempt to apply the expansive New Jersey state constitution First Amendment rights, to apply those to an HOA. We won in the appellate courts and lost before the New Jersey Supreme Court. So to be continued, this battle continues. The ACLU is quite interested in this issue. So let's summarize. Common interest development boards and officers make very important decisions that affect the lives of their fellow residents in all these areas that we've talked about. They are, for the most part, not very well prepared and not very well supported to do these things. They are dependent on unregulated professionals that many small associations can't even afford. And so they sometimes make mistakes. There are several standards that courts might apply in reviewing these decisions, and we've covered them in detail. The core is the notion of fiduciary duty and the business judgment rule. There are many circumstances in which you will find the standard of reasonableness being applied, and rarely quasi-governmental review. And that concludes our presentation.